Hi, I am Jacob Stein, and I'm a partner in Allianz Los Angeles office, and I'm also the global chair of Allianz Private Client Practice. Allianz is an international law firm, and in our private client practice, we represent individuals and families with respect to the many legal issues that relate to their wealth. Estate planning, tax planning, asset protection planning, and moving wealth around the world. We represent everyone from the middle-class families trying to hold on to what they have, to some of the wealthiest individuals in the world engaging in some very sophisticated planning. I have been practicing for many years. I also lecture a lot, and I would like to share some of my knowledge and experience with you. Today, I would like to discuss a topic that comes up often, which is how do you protect your personal residence from creditor claims? So for most of our clients, their personal residence is their most important asset. It is important because it is often a significant portion of their wealth, but it's also often important for more emotional, sentimental reasons, right? This is where you live. This is where your stuff is. This is where your kids are. You want to hold on to that, right? That is your sense, in a large way, your sense of identity. So how do we protect the personal residence? So to a large extent, it depends on which state you live in, right? Because different states have different laws with respect to protecting the personal residence. So let's talk about that a little bit. In every single state in the United States, some amount of equity in your home is exempt from creditor claims, and it varies greatly. There are states where the homestead exemption is around $20,000, and there are states where the homestead exemption is a few $100,000, and then there are states where the homestead exemption has no monetary limit, right? It can be $10 million, and it's exempt and protected from creditor claims. So you have to know, first of all, what is your state's exemption? So for example, if you own a home in Florida, there is no monetary limitation on the value that is protected, right? You can have a $10 million mansion in Palm Beach and you owe money to whoever, right? And that residence you have in Palm Beach is protected. Now that has to be your primary residence, right? You have to reside in that home. It cannot be like a second home or a vacation home or a rental property. It has to be your residence. You have to be a resident of that state. In California, the homestead exemption, for example, ranges from $300,000 on the low end to about 600-some thousand on the high end, depending on which county you live in. So it varies greatly from state to state. Aside from the homestead exemption, how else can we protect the property? So let's say that we have clients who live in California, as an example, home in Los Angeles. The home is worth $2 million, and there's a $500,000 mortgage on the home. So that means there's $1.5 million of equity in that home. Well, in Los Angeles County, only the first $600,000 of equity is exempt from creditor claims, which means that if our client gets sued and there is a judgment against that client, the plaintiff will be able to take the judgment, record the judgment with the local county recorder's office. The judgment attaches as a lien to our client's home, and once that lien is in place, the creditor can foreclose on that home, right? There's a foreclosure sale, the county sheriff sells it at an auction. Our client will get their $600,000 of the homestead exemption amount, and that remains protected once they put it into the bank account. The bank gets paid up their $500,000 that they're owed on the mortgage. The county sheriff gets paid the costs of the sale, and the rest goes to the plaintiff. So what options does our client have to protect that resident? So the $600,000 homestead exemption does not go far enough when you have $1.5 million of equity, right? You still have $900,000 of equity to protect. So what options do we have? So I will describe some of the most basic options that we have, but there are a lot of different variations on these options. So option number one, our client can sell his residence, because if they sell their residence, they no longer own real estate. They now have cash in the bank. Cash is a much easier asset to protect than real estate. So if you think about the home that you live in, right? First of all, the fact that you own that home is public information. Whatever you do with that home, right? If you transfer title of the home to someone else or something else, right? That is also public information, easy to trace for any plaintiff or creditor. And then a local judge always retains jurisdiction over that piece of real estate, allowing the plaintiff to potentially reach it, right, under the right set of circumstances. But once the home is sold and the client now has cash in the bank, well, cash can be moved to a different country, right, to some sort of, let's say, an offshore structure as an example, and really be made unreachable and be placed beyond the jurisdiction of a US-based court. So for clients who really need to protect that home, who really want to protect that home, right, when they're in a dire set of circumstances, very aggressive plaintiff, a lot of money at stake, our number one recommendation is seriously consider selling your home. And you may not want to do that. You may not want to disrupt your family. You love the home that you live in, right? There may be income tax consequences on the sale. But you have to realize that if you try something else and it doesn't work, if it doesn't work, the plaintiff can still force you to sell that home. You still have to move out, right? You still have the income tax consequences on the sale, and you no longer get to keep the sale proceeds, the equity from the property. Right now goes to the plaintiff. I would rather see you sell it yourself today and you keep that equity, right? Maybe it's sitting somewhere else. It's not in the home that you really want, but at least tomorrow you have the ability to get that money back, put it back to good use, buy a new home, right? So option one is sell the home. Option number two is to encumber the home, meaning place a mortgage, a lien on the property. So what can we do to drop that equity from $1.5 million to whatever the homestead exemption amount is, right? So if it's in LA, it's 600,000. If it's in Nevada, it's 500,000, right? Whatever the state exemption is. Because once the equity is down to the homestead exemption amount, there is nothing that a plaintiff can do. They're not able to foreclose if the available equity does not exceed the homestead exemption amount. So maybe you can go to the bank and borrow money, maybe refinance the mortgage, right? Pull cash out. Maybe you can get a home equity line of credit, right? Maybe we can engage in some sort of a transaction that looks like you borrowed money. It's not great, but better than doing nothing. Okay, so option two, reduce the equity, and this is what's commonly referred to as an equity strip. And then option three, and this is probably the most frequently used option, is transfer title out of your name. So you keep the residence, you continue living in the residence, but you no longer own it. And here the question we get from clients most often is, well, can I just transfer the home to my kids? Which is, I think, a very natural question to ask. And the answer is yes, you can, but maybe that's not a great idea. Because if you transfer the residence to your kids, the kids may now have a target on them because the plaintiff is going to sue whoever you transfer the residence to. So if you transfer it to your kids, to a relative, to a family friend, that is not going to be the person that's being sued by the plaintiff trying to recover the transfer of that residence. We prefer transferring to a trust or to a legal entity. Let them sue that, right, as opposed to a real person. So the structure we most often see and use is transferring the residence to an irrevocable trust. Irrevocable trusts are amazing at protecting assets. They're very flexible. They do allow you to retain control. We'll talk about that in other videos. And in practice, over the past nearly 30 years of doing this, we have found irrevocable trusts to be extremely effective in protecting both personal residences and other assets. Understand there are many different ways to sell a residence, right? For example, it can be a sale to a stranger for cash. It can be a sale to an insider, and then you lease the residence, continue living in it. There are different ways to encumber the residence. There are different mechanisms for the transfer of residence, different structures you can transfer it to, right? That may be all subjects for future videos that we can come back to. But I wanted to give you this brief overview, 3 basic options of protecting the residence. This is your starting point. Sell it, encumber it, transfer title out of your name. Thank you for listening. I'm Jacob Stein. Please reach out to me with any questions you have on asset protection planning.